Okay, good day, Leonard seniors and colleagues. Welcome to the very last day of our course on debt recovery and asset tracing. And on behalf of Tobena Erojikwe, the chairman of MBA Institute of Continuing Legal Education, I wish to respectfully welcome you all once again. It's day 7 of 7 of our course, and we're delighted to have you here once again. So we've had 6 very insightful presentations in the last 6 days. And today we're going to do something very different and interesting. So in as much as it is important for us to acquire the necessary technical skills and know-how, it is also very important for us to take a step back and hear from what some of us will say the horse's mouth. And in this case, the clients regarding what their expectations are when it comes to debt recovery and asset tracing. And so today we'll be hearing directly from our clients and leading users of our services. So today we are privileged to have 2 very experienced in-house counsel to share with us typical expectations and perspectives of clients when it comes to debt recovery and asset tracing. We have Mr. Chidi Okezie, who is the country head of legal and group company secretary for Stanbic IBTC Holdings PLC. I also have Ms. Temitayo Adegoke, Group Chief Legal Counsel and Company Secretary of Sterling Financial Holdings Company PLC. Again, I'm not here alone today. Previous days have been moderating all by myself. So today I have company, I have a colleague, Susanna Adeoye, founding partner, Warrington and Co., who will be assisting in quote, interrogating our panelists today. So I'll yield the floor to Susan to take the citation of our our panelist, and thereafter I'll just do a bit of housekeeping and then we'll go straight into the panel session and discussion. Susan, you have the floor, so you can introduce panelists to our colleagues. Thank you.
Thank you, Dr. Odofia. Thank you, panelists and senior colleagues and members of the community. So I'll go straight to reading Mr. Chidi Okezie's profile. Mr. Okezie has about 25 years work experience spanning across company secretarial, legal advisory, dispute resolution, business administration, human resources, with extensive and broad international exposures in corporate governance, enabling support services and corporate strategy. He is also highly knowledgeable in issues around corporate communications, management process, customer service, security documentation, as well as basic accounting and finance. Mr. Okezie holds a Bachelor of Law degree from the University of Lagos in 1996. He attended the Nigerian Law School and was called to the Nigerian Bar in 1998. Mr. Okezie is also an alumnus of the University of Chicago Booth School of Business, as well as Stanford University Graduate School of Business, California, USA. Mr. Okezie joined Stanbic IBTC in April 1999, serving variously as legal analyst, legal officer, and head documentation in the Legacy Chartered Bank PLC, where he started his career. He was the pioneer company secretary legal advisor of Stanbic IBTC Pension Managers Limited, a position he held until November 2013. He also currently serves as country head of legal and group company secretary for Stanbic IBTC Holdings PLC, a position he has held since 2019. He is a non-executive director on the board of Stanbic IBTC Trustees Limited. Mr. Okezie, you're welcome.
Thank you very much.
Thank you, sir. Our second panelist is Ms. Temitayo Adegoke. Temitayo Adegoke currently serves as the Group Chief Legal Counsel and Company Secretary of Sterling Financial Holdings Company PLC, a non-executive director of the Alternative Bank. Her professional experience, which spans over 2 decades, started with her role as an associate in the law firm of Alukwano Yibode. She thereafter joined the legal department of First Bank of Nigeria Limited, After her time at the First Bank, she assumed the role of General Counsel and Company Secretary at Rand Merchant Bank Nigeria Limited. She joined the Sterling Group in 2019 as the Chief Legal Counsel and Company Secretary of Sterling Bank. As the Chief Legal Counsel, she pioneered unique practices, developed agile teams, and improved efficiencies to support business growth and continuity. In her current role as a leader with a cross-functional mindset, she leads diverse teams across the franchise to deliver the group's strategic goals and objectives. Temitayo has a bachelor's degree in law from the University of Lagos, a master's degree in law from King's College, University of London, and an MBA degree from Warwick University, UK. She is an alumnus of Said Business School, University of Oxford. Temitayo is an honorary member of the Chartered Institute of Bankers, a member of the International Bar Association, and Chartered Institute of Arbitrators, UK Nigerian branch. You're welcome, ma'am.
Thank you very much.
Thank you, Susan. Yes, thank you, Susan. I think, okay, I'll just do a bit of housekeeping before we go to into the session. So I reckon that attendees may have questions in the course of our conversation or discussion. So I appeal to you so that we won't break a line of thoughts. You can use the Q&A tab to send in your questions, not the chat room, the Q&A tab to send in your questions. And at the end of our conversation, hopefully we'll have enough time. We'll take some questions as time would permit. So having said that, we'll go right into our discussion today. And again, I'd let Susan go first.
Okay, so the first question is to Mr. Okozie. Now, when you're considering external counsel in debt recovery matters, i.e., what key performance indicators do you prioritize when evaluating their performance? Oh, sorry, I've gotten that wrong, sorry. Let me rephrase the question. What factors do you consider when selecting external counsel for debt recovery matters? And how do you prioritize these factors?
All right, thank you very much. And also thank you for the opportunity given to me to be a panelist at this session. It's greatly appreciated and I'm happy to be here. So, I mean, for financial services, you know, debt recovery is unfortunately one of the things that we have to deal with in the financial services industry. We are in the business of giving out loans. And because that is our primary job, we sometimes unfortunately have to deal with situations where a debtor is unable to pay back a debt, and we then have to seek assistance from external counsel in the recovery of the debt. So what are some of the factors we consider and how do we prioritize them? I'll probably just run through a few of those factors. One of them primarily would be the reputation and track record of the solicitor in question or the law firm in question. So we usually look for a solicitor, a law firm that has a strong reputation for successful debt recovery cases. We check the references. Have they worked for other banks? What has been their success rate in terms of recoveries? Because we know that that is one of the key things that we would need to consider before we are sure that we will achieve, you know, a very positive outcome. We also consider specialization and expertise as well. So we know that it's not every law firm that specializes in debt recovery. So we lean more towards a solicitor or a counsel who specializes in debt recovery. And we know that there are not that many of them who have that specialization or expertise in debt recovery cases. So it's very crucial that we're able to identify counsel that, you know, are able to navigate the complexities that come through from debt recovery processes. Then thirdly, we also look for an external solicitor or counsel that has a deep understanding of banking and finance laws in Nigeria. This can be very invaluable when it comes to, understanding the regulatory framework that can help with recoveries, in debt recovery matters. And we also, that's a fourth point, we also consider communication and responsiveness of that external counsel as well. So what is their communication style? How responsive are these external solicitors? Are these solicitors the kind that we have to be breaking our backs in order to get information from them? Or are they IT savvy? Are they the ones that we will forward emails to or forward documents to, and then 2-3 days they haven't checked their emails in order to provide us a response? So how prompt are they in responding to queries? How prompt are they in keeping the lines of communication open? So communication and responsiveness is very, very important to us. But we also consider the fee structure and cost. So what's the law firm's fee structure when it comes to debt recovery? Does it align with our own budget and our expectations? And we want to have some measure of certainty and transparency around cost. We don't want any surprises. We don't want a situation where a law firm suddenly comes up and says, I've incurred so and so and so and so expenses, and the law firm never discussed it with us. That can be very disheartening, especially when we know that we are walking a very, tight line or tight rope when it comes to recoveries. And so if we're spending all the money on paying the external solicitor and then there's no hope of recoveries, then we might as well, go and have engagement with the debtor rather than having to spend all the money on the external counsel. So cost, fee structure, and transparency regarding cost is also very important. And also, we also look at the kind of resources and support staff that the external counsel has. Is he a lone ranger, or does he have the required resources and support staff who are well equipped? Because we know without this, if you are dealing with a solicitor where he is the one-man riot squad, let me use allow me to use that term, then it will then be a challenge, because he'll probably have his hands into too many things, and then responsiveness might be a challenge for that counsel. So we need someone who is effective, who is efficient, and we believe that if they have support staff who are well equipped, then they can be able to achieve that responsiveness and efficiency that we require. And we also consider location and accessibility. And what do I mean by location and accessibility? You see, depending on the nature of the recovery matter, we would rather prefer to select a solicitor that is located either where the debtor is or resides, or where the subject matter of the debt or the collateral is. We will not, for instance, go and take a counsel or a solicitor in Lagos to be pursuing a debt recovery matter in Kaduna. That certainly will not work, because ultimately that increases cost as well. And then maybe one last thing I would probably want to point out is the issue of conflict of interest. It's not, we usually, particularly in very big ticket debt recovery matters, we would want to find out from external counsel, has that counsel done anything for that debtor before, whether directly or indirectly? Have they worked together? Even with a related party of the debtor, you could have a company that is a group of companies, and therefore maybe one of the companies under that group is the debtor, and maybe the solicitor has done work for another member of that group. We would want to know, because if there is some level of conflict, then it will impact the ability of the external counsel to pursue that debt recovery matter effectively as well. So those are some of the things that we consider in order to determine who we would select, in a debt recovery process.
Thank you very much, Mr. Okezie. So we move to Mrs. Adegoke. And our question for you, to you is this: how do you assess the performance and effectiveness of external counsel or solicitor in debt recovery matters? So we're looking at what are the key performance indicators you prioritize, and when evaluating their performance.
Thank you. And thank you everyone for this event. I think it's nice to share these insights with our colleagues so that we can all work better together to support ourselves, because in the end, we're all in this together. When we're looking at KPIs for our debt recovery client and solicitors, we have the quantitative and we have the qualitative KPIs. So the quantitative ones are fairly certain, and I would be looking at things like, what's the person's turnaround time? What's the person's speed like? There are certain things that you want to do in debt recovery, and you know that you need the elements of surprise. So you're thinking to yourself, you want to measure how quickly a lawyer can deliver for you. So that's timeliness. And there are certain things that, take time, so you understand that. But so I'll look at timeliness, and that can be easily measured because you just look at the duration that you anticipate. You set the timeline together, and then you can check performance at the end of the timeline. The other point, which Chidi has already spoken to, is the costs. So for us, because we internally always have a budget, so part of what we're looking at in terms of KPIs, where do I get the most value for a very decent price? So costing is a KPI for me. So invariably, it's going to be a KPI for whichever counsel I pick. Again, this is a quantitative one. So what I just need to do with the counsel is align with budgets and ensure that everything all in, as Chidi mentioned, all in, I'm not exceeding that cost, he's not exceeding that cost, she's not exceeding that cost. So those are the quants. The other ones are the qualitative ones, and they're softer issues, a bit more difficult to specify and have a proper checklist for. But you do want to you do want to measure what I would say the relationship management. I think that's the way I can put it. So I've had counsel that when we are done with the matter, and in some cases we have a contingency fee arrangement, and contingency fee, as we all know, means that you recover as there's recovery. And I have relationship management issues with my counsel when my counsel agitates and insists that I should pay upfront, even as I have not recovered funds. So relationship management issues are the softer ones and difficult for me to tell you in clear terms the KPI, but it would be things like that. It would be, what's this person's attitude towards money? It's an issue for us. It's a KPI. What's your attitude towards money? Are you going to be looking at money above everything else? We're not looking to disrespect our colleagues and not pay for work, but if I've not received money, for instance, how can I possibly pay you? Trust index is another KPI. How do you deliver? How much can I trust you that you do not expose me to any reputational issues? I've had counsel work with us. Counsel encouraged us at the time to file a petition against a judge. And it wasn't, I would say that it wasn't my team, but because in my team, we kind of have a recovery function that is also different from the legal function, but we do recoveries as well, to some extent in legal. And we had counsel that gave us advice on petitioning judges. It's not always the easiest thing to do, because you can imagine that you're in the industry, you still have to have matters before the judge. And so we did petition the judge. And when the judge came back on us strongly, really strongly, the counsel simply told us, it's your problem to solve. now you have to solve it. And the judge was adamant. He was insisting that my executive directors appear before him. And we had to appoint another counsel to resolve that for us and help manage the judge and get the matter handled. So those relationship issues, trust index, can I trust you? It's a KPI for me. Your costing, are you going to take me above what we've budgeted and what we've agreed, and your turnaround time? I think these are some of the things that would be key KPIs for us. I'm trying to see if I wrote anything else down as I was thinking. Yeah, I think altogether, they impact the efficiency of the council, and they impact how I would measure the council's performance. Thank you.
Thank you, Ms. Adegoke, for that. The next question is for Mr. Okozie. What strategies do you adopt in sustaining a smooth and productive collaboration or relationship with external counsel in debt recovery matters?
Yes, thank you very much. Maintaining a very smooth and productive collaboration is very key, is crucial, because it will help to minimize risks. It will also help to minimize costs as well. And, some of the things in reflecting on this question, some of the things that come to mind, that we do practically, include one, for instance, we set clear and defined expectations. So we clearly outline what our expectations are, regarding whether it is the scope of work, whether it is the timelines, whether it is the reporting requirement, how often do we need you to come back to us, and then also the communication channels as well that we employ. And then we try to also help external counsel to understand what the bank's policy is, what our internal policies, what our internal procedures, what are our goals regarding debt recovery. Like has already been indicated, sometimes if from the very beginning counsel is more interested in, look, pay me this upfront, whether or not, I've had to deal with a client, for instance, where an external counsel where we agreed on, say, X, maybe say, for instance, 100 Naira would be your fee for recovering on this. And the external counsel says, okay, pay me the 100 Naira right now upfront. When you've not even started, you've not even done anything, and you say, I must pay you the 100 Naira now. So whether or not you recover anything, you've already gotten your monies up front. I told him very clearly, I didn't think that was fair. So what's your interest in the matter now? Is it the money, or is it in assisting us or collaborating with us in finding a solution? So that's why it's important to set clear expectations up front. That's one of the ways that would help us to have a very smooth collaboration. And also, secondly, is regular communication. We always want solicitors that would regularly, whether it is a phone call, whether it is emails, you finish from court today, you don't wait until the end of the month before you send us an email, you send us an SMS, you just notifying us, this is what transpired in court today, the next adjourned date is this. That regular communication is very important. Let us know what is going on, because sometimes it could mean that depending on how things are going, we could change strategy midway based on how we communicate. You could even be able to advise us and tell us that because of the way this matter is going out, we would suggest that, this application is filed at this time, or a different witness be brought, or we need additional documentation. But if that regular communication is not there, you're waiting till the end of the month, or you're waiting for us to chase you for information, then it then becomes a challenge. Then also, we, on our own part, know that we have the responsibility to furnish external counsel with regular information, relevant information, documents that they require in order to be, efficient and effective in handling their debt recovery matters. So we we don't starve external counsel of information. We don't starve them of documentation. We don't starve them of what they need in order to be able to carry out, their job, effectively. And then very importantly, we monitor performance very closely. So are external counsel adhering to quality standards? Are they achieving the desired results? We are constantly monitoring. Look, we have had situations where we have to debrief external counsel. Say, look, please, we are not interested in pursuing this matter anymore. Or we would basically tell them, return all our files, return all our documents, we'll hand over to another external counsel. So, and that we can only achieve if we are monitoring performance effectively. And on the softer side of things, we try to build a very strong relationship with external counsel, very positive, very professional relationship with external counsel as well. We believe that, that relationship should be based on trust. We believe that relationship should be based on mutual trust and mutual respect, sorry. We also believe that it should be based on collaboration. So we invest time to know not just the managing partner. Yes, a matter may involve the managing partner, but he may have a team that he's working with. So we invest time to also know who are the direct persons that are working with, build a rapport and understanding with them as well. And then one of the things we always consider as well, which some solicitors don't like it, but we also see it as a way of fostering that collaboration, is we incentivize performance. So performance-based incentives we see usually works a lot, especially when the incentive is very it's quantitative. So for instance, I could tell you that I will pay you a base fee. However, if your success is X, then I will pay you X percentage of that to you. And that success fee will then become a larger portion of your reward, basically for the outcome that we expect. So we try as much as possible to incentivize external solicitors based on performance, and because we know that would encourage them to also put in all their effort, into, and it's worked in a lot of cases. And we also constantly, like I said before, review and evaluate the effectiveness of the collaboration as well. Is the partnership working? Is the relationship working? If it's not working, can we end this relationship? Or are there things that we do we can do to make it better? So we appreciate external counsel that likes to receive feedback as well, who welcomes feedback and also sees ways by which they can improve. So those are some of the things that we do, or some of the things that we will put into consideration in making the relationship more collaborative, smooth, and productive.
Thank you very much, Mr. Okezie. So we're back to Mrs. Adegoke. So the question this time is a tricky one. So from a very practical standpoint or perspective, and from your experience, to what extent would the fact that a counsel who had previously represented a debtor or debtors against a bank, maybe your bank, work against that counsel's ability of getting instructions subsequently, or maybe in future, from your bank or from a bank?
Thank you. So I think context is everything. There is a possibility that it could impact choice of counsel, but context is everything. There are law firms that are, they've built their reputation around working with banks, and they don't, as a practice, take cases against banks. I respect them and I work with them as I need to. But at the same time, we hire lawyers because they have certain skills and because the cases at hand call for certain expertise. When Chidi was speaking earlier, he was talking about different kinds of things that he looks at when he's going to brief a council. It's not very different from what I do, because we're in the same shoes, we're wearing the same shoes. So we all look at the same things. So when I now want to hire that lawyer, because the lawyer has at some point acted against the bank, do I rule him out? Not necessarily. I would look at certain things. You know, we spoke to trust index. I will speak to character. Now, when you talk about character, we all know that's like the baseline of who a person is. What's the character of the counsel as he did his work when he was against the bank? What kind of professionalism did he demonstrate? If he was very professional, and indeed, I can see that objectively, and not just me, it would be everybody involved in the process. We may not necessarily deny that counsel the right to work for the bank, because there may be matters that, like I said, we would need that counsel's skills for. And if we do, then we want to engage. But if the character is such that is underhand, is full of nastiness, then there is really no reason why we would go back to such a counsel. One of the first counsels that I worked with when I took my current role filed a case against the bank. It was a case that, in his opinion, warranted contempt proceedings against me, my office, yes, and my MD, and a number of us. But I work with that counsel today because he's a professional. And what he did at the time was also being professional. He was trying to represent his clients to the fullest. And when I needed his expertise for something else, because he fits the criteria that Chidi has already advised the House, I called on the council, and we have a very good professional relationship. And I would just expect that if he's going to do anything, if he gets approached by someone who he knows will make him have to, work against the bank, disclosure. That's what my counsel owes me, disclosure. And that's what a number of them have done. If they're working for us and they find that they are now being called by a counterparty, most likely debtor, they come, they disclose to us, and we take a view, and we know what's to come because they are professional. But where we have found one or two people conduct himself, herself out of character, we have taken a view that we would also not continue relationships with such people to protect the franchise. So like I said, context is everything. I wouldn't say that it's a downright no, because you might need such a person, in your own court in future. But what's the person's character? Is the person a professional? Is the trust index high? Are there disclosures? And you look at all those things and you make a call.
Thank you, Mrs. Adegoke, for that. Our next set of questions is for Mr. Okozie. What are the typical challenges you face when seeking to recover debts? And how do you deal with those challenges before exploring external help?
Thank you. Of course, debt recovery on its own is a challenge within the context of Nigeria, and we do face quite a lot of significant challenges, and Temitayo will tell you it's something that is constantly evolving and dynamic, and as new situations come, we continue to seek for ways by which we tackle those challenges as they come up. One of the challenges that we typically face, of course, is the legal and regulatory framework. We are in a very highly regulated industry, the banking industry. If you are a listed entity, you are a financial institution, you are governed by CBN, sometimes you are governed by SEC, sometimes you are governed by NGX. you are governed by NDIC, you are governed by, so AMCON is there with their own challenges as well. So the legal and regulatory framework is itself complex on its own. And before you proceed to recover a debt, you have to make sure internally that us as a bank, as a financial institution, have we complied with the rules before we even begin to say we want to go and recover a debt? So for instance, did we charge the correct interest rates? Have we perfected the collateral? When the facility became due, did we call the facility in line with the terms of the facility agreement? Did we accelerate the debt in line with the terms and conditions? So some of those, because those things, those legal regulatory loopholes are things that a debtor could probably take advantage of, and then truncate or scuttle our attempts to recover the loan. So internally, we must make sure that we have complied, we have navigated through the complex regulatory framework that would ordinarily make debt recovery a challenge. And then another challenge we face is the debtor's insolvency. I mean, debtors can become insolvent. Imagine where a client's business genuinely goes belly up and there are no assets remaining, and the client says, I have lost everything, basically, either because of socio-political and economic upheavals. I mean, many of us have been here in the last 1 year, even though we do not want to begin, this is not an economic summit, so we don't want to talk about what has happened in the foreign exchange market and all of that. We saw businesses that declared losses, businesses that ordinarily are supposed to be doing very well. People will be looking forward to receiving dividends, and suddenly they are declaring losses along the line. And if they had challenges servicing their debts, imagine where a clause in a loan agreement is that you must remain solvent, and then you come back and say, oh, my shareholders' funds have been wiped out. So you then have to decide, am I going to enforce, or am I looking at the fundamentals of that business, and am I telling myself this business will pick up in a couple of years' time? So is it better to go after the debtor now, or look at the fundamentals of the business and tell myself, okay, the business will pick up, let me restructure the loan? So debtor insolvency is a very critical one. And then we also have, of course, something that many of us will be very familiar with, the length of legal proceedings in Nigeria. It is slow and time consuming. And I honestly do not know how we are going to get ourselves out of that mess. I mean, we have some matters that are still in the court of first instance since 2015. 9 years are still at the court of first instance. I was discussing with my colleague this morning. We received an update on a matter which was, this is a debt recovery matter. The debtor lost at the High Court, appealed to the Court of Appeal, lost at the Court of Appeal, and now the matter, he has now appealed to the Supreme Court. Guess when the appeal was filed at the Supreme Court? 2013. 2013. And the matter came up for hearing yesterday. And guess what? The Supreme Court adjourned the matter for definite hearing to 2026. This is a 2013 matter. It went to the Supreme Court in 2013. Now, definite hearing in 2026. It's very frustrating. And so in some instances, we find that we may even fare better having to negotiate maybe with the debtor and see, okay, is there a possibility of restructuring the facility? Maybe, to help the debtor to probably be able to recover some part of his business and pay us back in the process. Is there a possibility that we might genuinely see that, oh, this debtor is struggling. And rather than, they use this common phrase, penny wise, pound foolish. So rather than go, if it's going to cost me 100 naira to recover a debt of 200 naira, but the debtor is saying, okay, I can give you 150. And I can look at the opportunity cost of that and say, okay, can I have the 150? And then I would cut my losses and move on, rather than pursuing a debt recovery action that I do not know the end of it. So those are some of the challenge. And of course, like I mentioned in all of this, a debtor can object. And if a debtor objects to the debt, he can always bring up so many defenses as to why they will not pay the debt. Then part of the challenge too is asset tracing, where you are not able to find or identify assets that belong to the debtor. And I'll give you a simple instance. There used to be a time when we used to be into haulage. Because of the challenges we faced in that sector, we had to step away from that for a while, where you actually had to give credit facilities to major distributors for the conglomerates, and you finance the purchase of, say, trailers that the debtor would use to haul goods and services to various parts of the country. And then after a few years, you can't even find the trailers. They have all disappeared, and you are now left wondering, were they disposed of? Were they dismantled? So you can't even trace the assets anymore. They are nowhere to be found. So those are some of the challenges. So we find situations where we may even have to stop a certain line of lending because of the challenges. So those are some of the challenges that we encounter. Of course, okay, I forgot to mention one, which is reputation management. If recovering a debt is going to impact on the reputation of the bank, or the way a debt recovery process is going to be handled is not going to be professional, it's not going to be ethical, and it's not going to be transparent, and may impact on our reputation, then it may be a challenge for us to go into that kind of debt recovery action as well. So those are some of the challenges that we face as a financial institution.
Thank you very much, Mr. Okezie. So the next question is for Mrs. Adegoke. In 2020, the CBN, Central Bank of Nigeria, and Bankers Committee came together and initiated the GSI, the Global Standing Instruction, which was aimed at improving credit repayment culture and reducing non-performing loans. So could you shed more light on this initiative and how effective it has been so far? And that's if it's still in operation. Thank you.
So the GSI, as you noted in your question, is something that the CBN developed and released to us in 2020. To work, the CBN mandated us to include clauses in our offer letters that indicate that customers accept and agree that where they are owing and the loan remains unpaid, we can activate the GSI mandate. They gave us a mandate to debit their accounts across the industry. Now, as lawyers, we know this can only work for individuals, because for corporates, it's a different conversation. So for individuals, yes. The way it's been implemented is that it's kind of like a plugging in solution. And basically, for us in Sterling, I can confirm that for our digital loans, it's worked very, very efficiently, because once the digital loan repayment is triggered, the GSI mandate is automatically triggered, the repayment is due, it's outstanding, and then there is just a sweep that happens through Remita. The banks are not even the ones involved themselves. Remita is the one connecting all of us together. It's been very, very successful. It was so successful that the CBN in 2022 released further guidelines on how to use the GSI and advice that we can begin to use the debits can be continuous. So previously there was some restriction on how regularly you could trigger the GSI, but now it's continuous. We find it very helpful. The only thing I would say is that we then have an interesting other side on the retail side, spike in litigation. So customers are owing, you issue the default demand letter for recovery, you trigger the GSI because it's inside the loan documents that the customer signs, and then the customer sues you for debiting his account. So we just have the litigation spike coming up on the GSI cases, and you're wondering, this is actually, you know, this is not a good use of anybody's time. Debtor is just being bad here. You're owing, you've agreed, you signed it, it was there, and we've used it. You had the money. Why didn't you pay? Why didn't you approach us and say to us, you know, maybe I have some difficulty, maybe we can restructure, maybe something happens. You wouldn't do that. When we then take what is ours, because really it's ours, because you have it sitting elsewhere and you didn't do anything about your loan, you then sue us. And again, it's colleagues, you and I, is us, we are the ones that represent the borrowers in these situations. So the GSI has been a great tool for us, particularly with the digital loans. In Sterling, I know for a long time on our digital loans, we're very quick to use the GSI mandate, and we continue to make recoveries through that. We only wish that we would have perhaps our colleagues, as they understand how the GSI works and if they have the information, maybe advise clients that this isn't something you should pursue because it's really just a waste of everybody's time, because we then commit resources to it, and in the end, there's really no reason. There's no reason to. And where GSI has failed, I would say, where GSI has failed in that perhaps a debit was taken and it wasn't necessary, you would find that the money will then reverse to the bank where, like if we trigger a GSI mandate and we've taken enough and everything has been swept to Sterling, we're not going to take your money. Your money is there for you. So maybe it has left your account in GT, maybe it has left your account in Stanbic, but it's in Sterling. And then you bring a suit again on that matter. It's there now, it's your money. Use your app, transfer it, but you sue us. So I think it's a veritable tool, and I don't know why we're not advising our counsels and our clients when they want to initiate cases that don't have any real merit not to do so. That's what I would say about GSI. Thank you.
Thank you.
Sorry,
Mr.
I noticed Mr. Okezie was nodding. You want to add anything, or she said it all?
No, I was just nodding because I fully agree. And, you know, we're in industry, so we fully understand. And, you know, just to point to what Temitayo said, you know, we feel that counsel should work better at advising their clients, especially when it comes to free. I know, yes, counsel wants to make money, and a client brings a totally frivolous matter. Please tell your client, have the honor and the respect to tell your client that this is frivolous. But you tell the client all things are possible, but they pay me. And then you go and then file and sometimes you are even claiming damages for trauma and heartache and hospitalization that is even much more than the debts that the customer is owing the bank. So we find it disheartening sometimes when we see situations like this. So I agree with him, Taya.
Thank you, Mr. Okezie. Thank you, Mr. Madegoke, for that. And the next question is for Mr. Okezie. To what extent do you give external counsel autonomy in handling debt recovery instructions? And
yeah, okay, go ahead. Yes, sorry.
Okay, yes, let me just continue. Do you give them discretion to develop debt recovery strategies, or do you typically give specific directives? Are you still there, sir?
Yes, I am. Yes, I am. Yes, I am. Now, in determining the level of autonomy we give external counsel, we would, basically consider, for instance, one, what are our internal policies? What is our own risk tolerance when it comes to autonomy? If depending on the kind of risk we are willing to take and the kind of counsel, the level of maturity of the counsel we're dealing with, it will vary from case to case. If, for instance, a matter is complex, so if it's a much more straightforward debt recovery matter, sorry, I'm not sure, am I still audible?
Yes, you are. I can hear you.
So for more straightforward debt recovery cases, we may be more comfortable with giving external counsel a bit more autonomy in terms of how they develop their own debt recovery strategy. But if it's a much more complex case that might involve significant legal risk or might require some specialized expertise, then in such a situation, we would rather be more specific in our guidance to external solicitors. Then also, of course, the legal and regulatory framework is very important to us as well. So we want to ensure that external counsel is always complies or does his job within the ambit of existing laws. We would not go outside it. So whatever strategies you are operating must be within existing laws. We cannot have external counsel or external solicitor who will embark on self-help. You don't want a situation where in the process of recovery, we know that debt recovery process can go very wrong. And in some situations, it might even involve AFRI, where there are boxing matches in the course of debt recovery. And that could result in injury. That could even result in, the debtor now taking out a separate legal action against the bank as well. So we must ensure that external counsel is willing, ready, and able to comply or work within the ambits of the legal framework. And then we cannot overemphasize communication. Even if we grant external solicitors some level of autonomy, it is essential that they are maintaining open communication, and ensure that their strategies continue to align with the bank strategy and that they are complying with legal requirements. So long as they continue to communicate and we know what they are doing at every point in time, then it makes it easier for us to trust you. It makes it easier for us to understand the reason why you do what you do, and then we'll be able to support you as well in that.
Thank you very much, Mr. Okezie. We're back with Mrs. Adegoke. So the question is this. One of the topics we've had to deal with in the course of the training course is the use of mediation and negotiation for debt recovery and settlement. So again, from a very practical perspective, how effective do you find the use of alternative dispute resolution mechanisms like mediation and negotiation in debt resolution and settlement?
Okay. I'm afraid I have to start with context again. It's everything. If I find that my borrower is a very reasonable person, perhaps someone who's, come for a restructure, we've had conversations, we may try to use ADR. Perhaps we don't have even disputes as to the amount owed. It's a function of timing and all of those things. We may try to use ADR. And the reason is that nobody likes to have a bloated litigation portfolio. When Chidi was speaking earlier, Chidi said hears matters that Supreme Court since 2013. So you know that when you take on some of those debt recovery cases with all the strategies that we as our colleagues, also employ when you want to make sure you are, defending your clients, you find that the case drags. So it would be challenging every little thing, even when in substance, there's nothing here. So in such instances, when you look at it, when you think of that, and you think of your case, you think of your client or your customer, and you look at the sincerity of purpose, you might want to go to ADR. I may not even start with ADR in some instances. I might find that I need to litigate to the point where I settle. So it may not be ADR, through the body that we have. It may just be a negotiation. So in the end, it's a useful strategy. It's just that it may be one that I use after we have exhausted and drawn ourselves out of litigation, and then we want to negotiate and close because we can clearly see where that's going, and everyone wants to, close. So something I may use afterwards, but I may also use it when I want to start, if I find that the borrower is reasonable. But for banks, the general feeling is that when we go to ADR for customers that are recalcitrant, we are wasting time, because the ADR process takes away the elements of surprise, first of all, which you sometimes need when you want to recover. It takes away the elements of surprise. I want to, get into possession. Because that's possession is 9/10 of, ownership. So you lose the elements of surprise when you go to ADR. So it really is in those few cases where you find you have a borrower that is reasonable and you want to use a gentleman arrangement to close your issues, or you use it as a tool that you introduce after you have litigated and you have both established your rights and you've done that for a bit. You come back to ADR to try and settle and have everyone have the matter closed after a while. Some of the matters that are in court of appeal, if you look at it and you think maybe this is a time to do some kind of settlement, you do it then. But in the beginning, if you want to strike, and you sometimes need to strike if the borrowers are recalcitrant, you need to strike. You have to be honest. ADR will not give you that. Will not give you that.
Okay, thank you, Mr. Adegoke, for that. The next set of questions is can be classed as being in the Department of Career Development. Mr. Okozie, what advice or success tips would you give to a younger colleague or colleagues who are considering careers as in-house counsel in financial institutions?
Okay, thank you. I mean, if you're considering in-house career, maybe I will assume that you're in practice. Well, okay, let's not even assume you are a fresher. So you just left law school, and so you're thinking about coming to work as an in-house counsel. One of the things I would say is maybe first of all try to get a little. I think it's useful, no matter how small, to get a bit of knowledge in private practice a little bit, even if it is for 6 months, 1 year, you just get to see how it is on the other side before you come in. It helps a lot, because it helps you to be able to appreciate what you are going to see when you eventually come in. And then if you are thinking of coming in ultimately, something you should always have at the back of your mind, develop a strong understanding for the financial services industry. Are you staying updated with industry trends? Do you know the kinds of regulations that exist in the financial services industry? Stay up to date with those things. Do you understand the business model of the financial institution you want to work for. Let's remember that financial services industry doesn't mean banks. It can mean asset management. It can mean pension. It can mean investment banking. It can mean merchant banking as well. So the specific kind of financial services you want to get involved with, are you staying abreast with regulations, with rules? Do you understand their business model as well? So that is something that you should have at the tip of your fingers. Then you need to be able to build strong legal and analytical skills. It's very important. You know, you need to develop expertise in relevant areas of the law, such as banking law, if it is contract law, you know, financial regulations. You need to be an expert. You must be able to hone in your critical and, you know, problem-solving skills. Is something that you must be able to have. And then you must be an effective communicator. It's very important. You must learn how to be able to communicate very complex, you know, concepts in very clear, concise, and business-like manner. You know, a lawyer must remember that when he becomes an in-house counsel, he's going to be engaging with people, teams, departments that are not lawyers. And so many of these teams and departments don't like big grammar. They want you to be able to break it down in the way they understand. They know lawyers are always verbose. They want to speak big grammar. But when you want to work for a financial services industry, if you try to bring in your legal grammar, they will bring in their financial grammar as well. And then you would then find out that you are not communicating. So you must be able to, you know, communicate very clearly and in a business-like manner as well. And the only way you can do that is also understanding the industry that you belong to. And then you must be somebody that is very proactive. In every, when they bring scenarios to you, you must be able to anticipate the legal issues that could come out of that scenario, and then proactively, you know, provide legal advice that will be able to mitigate those possible scenarios. You must be able to identify areas of improvement in a legal process, in a legal policy. You must be able to identify areas of improvement. And then the financial services industry is a very ethical industry. You know that we deal with money. Money means we are dealing with trust. People must be able to trust us because we are holding people's monies. And so for people to be able to entrust us with money means they trust us. And so, are you an ethical person? Do you consider yourself an ethical person? Financial services is not where you come and steal money. If you have that mindset that is where you come and steal money, you will get yourself out of it faster than you came in. And so you must ask yourself, what am I an ethical person? Do I uphold the highest standards of ethics in my personal dealings now? Because when you expose sugar to an ant, it is then you will know that the ant is not very faithful, because it will go after the sugar. So you must ensure that you on your own, that you uphold ethics, you uphold respect for the rule of law, you uphold your conduct must be above board. And then you must also be someone that likes to collaborate. Use the opportunity to seek mentorship from in-house lawyers right now before you get in. So do you have friends, colleagues who are in-house lawyers? Seek to be mentored by them. You know, that way you will accelerate your learning, you will accelerate your growth. We have situations where some law firms second their lawyers to work in-house on specific projects. That happens. And so if you see opportunities like that, and your law firm, you know, is looking for, we're looking for somebody to second you to Stanbic IBTC, to Sterling, to Zenith Bank, to GT Bank, on a specific project, take advantage of it as well, because that will accelerate your learning and that will accelerate your growth as well. And of course, we know that the legal landscape is constantly evolving. So you must be willing to learn new skills. You must be willing to adapt to changes. There's a lot of IT now. You know, the new thing, the new wave now is fintechs, AI. How are you, growing your knowledge and skill, when it comes to things like artificial intelligence, when it comes to things like, financial technology? How do you see yourself in that? Because that's where banks are going to now. So how are you honing your skills? How are you expanding your knowledge? How are you expanding your expertise in that regard? So look for opportunities to add value beyond just the traditional legal responsibilities that you would ordinarily face. And if you do this, then you are really opening yourself to be a valuable asset that we would poach from the legal profession into the financial services industry.
Thank you very much, Mr. Okezie, for the very useful tips. So I think the last question, still on career development, before we take some of the questions from the attendees, is for Mrs. Adegoke. So what are the basic steps which young practitioners can adopt to position themselves for debt recovery instructions from financial institutions and banks?
Right, thank you. I'm going to try and share what I think you should do to, position yourself as an expert, because that's where you should start from. You want to be an expert in the field. So Chidi mentioned knowledge. That's basically that's the baseline. That's the baseline. You want to understand the sector, and you can understand the sector from outside. Make no mistake. I was fortunate enough to start my career in practice, and I worked with a firm which had a mandate the mandate was to look at CBN regulations and guidelines and advice periodically, I think on a monthly basis. So from my days in practice, I already started to know the regulations for bankers. When I transitioned into banking, with all sense of humility, I would speak to some regulations and my colleagues in-house didn't know them. Because then I understood in banking, I came to understand in banking that there was a department called compliance. From the outside, I just thought everything must be the lawyer's responsibility. You have to know it all. So when I got into banking, I realized, there's compliance, and compliance is in charge of regulations. But I was fortunate enough to start to understand regulations and look at regulations. And today I still, make an effort to follow regulations. Once they come out, once our compliance team share them, I want to understand what the regulations saying to remain relevant, since this is my industry. So I would say to you, it doesn't stop with the laws, because, how many of us did banking law even in university? And what was the subject really there? And if it was there, how many people did it? So how many people did insolvency law even? I think it's something that probably even started becoming more topical in terms of considering it as a subject in school after I left. Maybe now it's more common, not sure. So I would say study technical, get the practical, by, if it's CBN information, you want to get CBN information, SEC, to Chidi's points of asset management, it's all financial services, SEC rules, NSC. Just go and learn those things and make a habit of keeping in touch. The reason is that when you want to position yourself, market yourself, or you want to be given one to even do, you want to bring something new to the table, something nice. You want to engage with your customer, and you want to, because we will then be the customer or the client when we engage our counsel. You want to engage with the customer, you want to show that you have a deep understanding of what it is that the person wants you to to work on. For some recoveries now, especially with the way everything has changed and banking and technology are really fused, you do have to understand a bit more and a bit differently now to even handle some of those recoveries, because the landscape is changing. Banking as we knew it before, lots of perfection of title documents in Alausa, registry, all of those things. Assets are changing, asset classes are changing. It's a lot of digital play. So there's going to be recovery in digital play and recovery through different means. Indeed, an area that I think that people should go and start to position themselves in is even the criminal law aspect, because now we find that when you see headlines that no financial institution wants to see, you say this bank has been hit, something fraud, this one, that one, billion. When you see those things, what is it telling you? Somebody has to do recovery. And you will not want to stop with recovery in court. You want to go after criminal. So the competence for recovery is broad, and the demand is there. The demand is there because you want people that can help you work the system, with the police, with the law enforcement agencies, and get your money out. So knowledge, deepen your knowledge, deepen your expertise, broaden your skills, search for it. If you are fortunate, spend some time with a law firm where you can work with seniors for a bit. Don't be in a hurry to do it on your own. It's good to be an entrepreneur, and a lot of people are towing that path. But if you can, spend some time with people that have done it and people that have the reputation. It does something for your CV. Because we will remember you. This is that person that used to work with the law firm of X. I remember engaging with him, he or she. I remember engaging with her. She's quite talented. She was talented then. She can only do more and grow, from there. If you're not privileged enough to get into the law firms, seek mentors from these people. These experts, make them your mentors. Seek mentors internally, in-house counsel. Make them your mentors. They will give you these tips just through relationship, because now you've put us on a think about it and say it. If someone is mentoring you, you'll be telling you periodically as it comes to him or it comes to her. So that I would say is the foundation of everything. Then trust, of course. You want to make sure that if you're given the opportunity of even doing something small that may not be debt recovery, you ensure that you over-deliver. Your word is your bond. So if you say you're going to deliver on X day, deliver on, if you can, even before. And that way, when you've done that bit well, people can start considering you and thinking about you for recovery, because recovery is a big deal. Because when it comes in, it's good. It's really good for everybody. Then don't say no to the small stuff. They may give you a recovery that may be just small, maybe just one small thing, and just go and do that one, Win in those areas so that you can get the bigger ones. So don't turn your nose up at the small recoveries as well. Try and get them in that. Try and, be humble enough to ask for the small ones. Do them with the mind that once you've done those ones well, you will be able to do the bigger ones. So I think these are the things I can sort of throw out there. Be consistent, the quality of your work, because all those things speak to your brand and your testimonial. People will be talking about you. And, no, you can trust this person. His work is good. Her work is good. She's done something for me here or there. And that you can also use when you're positioning yourself. Talk about who you've worked with, who has given you at least one opportunity, what you've done there. If you did it well, it really helps. But if you didn't do it well, it will not help you too. Because I would say, oh, my brother Chidi told me that when this person worked for him or her, didn't do very well. Why do I want to hire that lawyer? So I wouldn't want to do that. So I think the fundamental, the baseline is that knowledge. You need to be knowledgeable, and you need to look at it beyond civil. Think of competencies around criminal, because that's this AI tech, we're not going back. And the more we find that money is missing through operational risk incidents, the more we're going to have to be looking at recoveries through means other than the civil courts. I think those are the things I would say to people who want to position, young lawyers who want to position themselves for recovery. Thank you.
Thank you so much, madam. Thank you so much, Mr. Chidi. Okay, Zie, it's been a very insightful session, and I can see a lot of feedback already. I think we still have time to take maybe 2 or 3 questions from our attendees. And there are so many people still online. So thanks to the attendees for your patience and active participation. And before we, pick a while, Susan sorts out 1 or 2 of the questions that are relevant to our discuss today. I'll just take some of the feedback online. I can see Zion Hilltop Zubairu says, thumbs up again and again. Thumbs up again and again to the wonderful and dynamic host and panelists. Esther Obasemo from Akure says this session is an eye-opener. Thank you, MBA ICLE. And of course, the panelists, I totally agree. It's been an eye-opener. Adeboboye Taufik Adekunle from Garki says, I thank the panel for this insightful and informative session. God bless you all. And I say a big amen to that. Ebuka Okafor says an amazing session. Thanks to the panelists for sharing from their wealth of experience. Money cannot buy this. I absolutely agree. Thank you, panelists. Thank you, MBA ICLE. I think we have time to take maybe 1 or 2 questions from the attendees. Of course, the questions are now coming in deluge, since I've made reference to that fact. But we'll just pick out 1 or 2 because we have to draw the curtains maybe in the next 8 minutes. Panelists actually joined us long before the commencement of the session, so we don't want to keep them longer than necessary. So, Susan, you can go with the first one that is relevant. We'll just pick ones that are relevant and then, yes.
Okay, thank you, Kobe, for that. So the first question here, which I believe is relevant, is how can the debt recovery fee be paid, especially with regards to court fees that may need to be paid up front, in order not to request for or demand for payment at the beginning of litigation? Was that clear? Did you get that?
Yes. Who do you want to take it?
I think you should take it in turn. If you could take it, if you can go first, Mr. Adegoke, then Mr.
Okay. Okay, thank you. So I think that our colleague may have misunderstood the point we were trying to make. We are not suggesting that fees will not be paid. What we found to be a bit difficult, and I would not even say difficult, I would say improper, is where you have a contingency fee arrangement. You would expect that counsel will build in expenses and will charge for that at the start of the case, and that is understood. But where your fee is contingent upon success, what we're saying is that if there is no success, you cannot ask to be paid. So if your success is as recoveries come in, it's when we get recoveries that we pay you to. If we don't have recoveries, we can't remit funds to you. So we're not trying to, and our colleagues must understand, we are in the same industry. We just happen to be on a different side for now, but we're all in the same industry. That's why we're here. That's why we're doing this together. So no one is trying not to pay colleagues. It's just let's understand that when it's a contingency fee arrangement, we don't appreciate being asked to make payments upfront when we have not made recoveries.
And just to add to what Timothy has said, I mean, in a lot of instances, what we also do is to agree, we can agree a base fee that we will pay you for filing the matters. So assuming, and we recognize the fact that you would need to do some basic, running around. So we could agree and say we will pay you X fee upfront to enable you file and execute whatever strategy that we have agreed. And then subsequent to that, we will then agree on, and it could be in the same letter of instruction, we could then agree how we would then pay you in tranches, the balance, and then maybe a success fee or an incentive fee at the end of the day. but it's important that, you know, we are in alignment in terms of, you know, the understanding that, look, if we haven't recovered the money, like Temitayo said, you cannot expect to be receiving the bulk of your monies. We're in the pain together. So help us share the pain. That's what we're saying.
Okay, so Kubi, I just want to do a follow-up quickly. So basically what you're saying, Mr. Okozie, is that what the banks will do is, or what you will do is agree like a disbursement or an expenses upfront, which you will release to the external counsel so they can do what they need to do. But in terms of professional fee itself, that waits until there's been recovery.
No, we can agree on a professional fee and then indicate that we will pay X portion of the professional fee upfront. Okay. We will pay the balance at this stage, and then add an incentive fee for any recoveries that come through as well.
Okay.
Yeah, so it largely depends on the complexity as well. Okay,
thank you.
Okay, so Abibullah Abdul Fattah wants to know if there is any post-call experience and office standard, I guess maybe quality of the office and furniture in the office for one to be listed as an external solicitor. Okay, office standard, maybe in terms of composition of lawyers and all of that, to be listed as an external solicitor to a bank.
Okay, I can see Chidi smiling too. Okay, so the thing is, there is no rule book, but because when you're going to be listed, we look at the complexities of the matters that we want to assign to you. You may not be able to get recovery when you have limited experience, because we are not sure that you can. And to Chidi's point, when he was explaining further, it will be difficult for us to say we are not going to give you anything. So we'll give you something to take care of, you know, filings, and even perhaps a percentage for starting the work. But how do we know that you can do the recovery? Because our recoveries are usually, you know, big. But it doesn't mean that you cannot work with us, which was the point I was making. You can do other things. You start out doing other things, you do them well, and then you can move into recovery. For my recovery lawyers, I would really like to see some level of experience. I'd like to see some level of experience or some kind of, should I say, references. So if you are fresh off the boat and you just got that really shiny wig and all of that, I may be a bit reluctant to put you on recovery in the immediate. And if I did, it might be a small recovery that you will then just know it's purely contingent, meaning that go and recover if you make money on a debt that I've probably written off. And I know that anything that then comes is just going straight to P&L because I've written it off. I can take that risk. So it's never say never, but to my point when I was giving the advice, I think it's good for recovery lawyers to get some experience, you know, in-house and with others, just a few years, cut your teeth on something, make some mistakes, learn from them, so that you will not use our cases, you know, as the mistake, you know. Don't use us as mistake. It can be very costly. So, thank you.
Yeah, so basically what we are saying is, I mean, if you choose to set up a law firm right out of law school, that is not to say that you may not be appointed as external counsel, but you will probably not get the very serious matters. You may probably start with garnishee matters and gradually begin to grow. Maybe we give you, go and conduct this search, go and do, you know. So basically, we are also grooming you to help you to also grow. Of course, you need to also, at the minimum, that you should be able to, you know, have a means by which you can reach you. You must be IT savvy in this 21st century. If you are not if you're not IT savvy as a lawyer, I mean, gone are the days. I still remember those days where for every little thing like this, you had to document a memo, you print memo. After printing memo, you will sign, then make a photocopy of the memo, stamp acknowledgement copy on the memo, go and deliver the memo, these days, everything is email, everything is, you say, so it's speed and efficient. So if you are not ready for that fast-paced environment, then better get yourself ready first before you then come to say you want to work for a bank.
Thank you very much, Madam and Mr. Okezie. I think we still have time to take one or two more questions. Okay, just two. Someone asks, what other services can lawyers render to financial institutions? So our focus is on debt recovery. So maybe we can just highlight that in addition without going into details.
Yeah, Tayo, you want to go first?
Okay, thank you. Apart from debt recovery, what other services can you render for us? We've spoken to a few of them. You can handle things like the bread and butter is what we call that, or maybe searches. You know, when you want to open accounts for customers, you want to make sure that the companies are properly registered. So that's a lot of CAC interface, searches. You can handle things like garnishes, which we've mentioned. You can handle perfections, which we've also spoken to. When you develop deep technical expertise in transactions, you can come on and work as a transaction counsel. Maybe the day that Chidi wants to help build another refinery somewhere, you know, you can do that. So there are different kinds of things you can do with the institution.
Thank you, Ms. Adegoke, for that. Mr. Chidi, is there something, do you want to add to that, or is that?
No,
fine?
I mean, basically she's mentioned, so you can work as a solicitor where you are drafting transaction documents, you're perfecting, like she has said, you're doing probate registry, you're perfecting at the lands registry, you are doing CAC work for us. Yeah, I mean, or you can then do minor litigations, the garnishee matters, you know, and all of that, yeah.
Yeah. Okay, thank you. The last question is, oh no, it's gone. No?
Okay, I think it was answered online.
Okay.
Gentlemen, I think it's a convenient time to draw the curtains.
Yeah.
Or else we wouldn't, I mean, like we say litigation, there has to be an end to litigation. So please permit me to once again immensely thank our panelists today, Mr. Chidi Okezie and Ms. K, for a wonderful, wonderful and very insightful session. And we didn't expect anything less. For those of us that know them very well, we are profoundly grateful. Thank you for your time. Of course, we know how busy you can be and how busy your schedules are, but thank you for finding time to be with us. You've been with us for, it's almost 2 hours now. We thank you. We cannot thank you enough. On behalf of Tobena Irojikwe, the chairman, MBA ICLE, we thank you and we thank you and we thank you. And we hope that in future, when we come to knock on your doors, you always open up to us. Thank you so much. I don't know if you have any last words for our colleagues before we call it a day. Any last words for our colleagues? Some are asking for contacts. Of course, search for their contacts. You can find them on LinkedIn. And okay. Yes, and the videos will be available on YouTube, so you can watch them over and over and over again. The most important information, important thing is the information they've given today, which someone said you cannot buy with money. It's not necessarily their contact. With the information, put them to practice, you can actually always get to them or get their attention. So I would just like to have their final words before we conclude. Thank you.
I want to say thank you. It's been very exciting and it's been a very good experience. Dr. Hubi Dofia was really persistent he tried reaching me, and initially I didn't respond because not because I didn't want to, but because I was really tied up doing some things. But he was persistent, and that's the point we're making. You know, when you want something, you keep going for it, and I'm really glad, I'm really happy to have accepted to do this. You know, seeing the comment, seeing everything is also somebody put a comment which it was just a comment, that wasn't a question, that maybe next time we also add an external lawyer to the panel to make it richer, so that we can get perspectives from the external counsel as well. And that would, I think, would make it even richer. So I just want to say thank you for the opportunity. It's been good meeting everyone online and interacting with you. And I hope that some of the things that we have exchanged today will be useful for all of us. Thank you.
Thank you. I would also like to write on what Timitai has said. You know, like our learned justices in the Supreme Court and Court of Appeal will say that I've read the judgment of my learned, and I concur. So just to appreciate you, Doctor, I call you Doc, and members of your team as well for the opportunity. And it's really been very enlightening, even for myself as well. And we look forward to this kind of collaborations happening in future. And then you can always count on my support. Thank you very much.
Thank you. Susan, any word from you?
I just want to thank the panelists. They've been wonderful. It's been a very, very insightful session. Thank you very much once again. And like Doctor said, we hope that when we call on you again, you would gladly open up the door to us. I also want to thank members of the community that have stayed along. Well done. And I hope that this was a very, very insightful session for you as well. To Doc and the ICLE team, well done for putting this together. And yes, look forward to more collaboration in the future. Thank you.
So lastly, again, on behalf of Tobe Nairoji, the chairman, MBA ICLE, I want to thank the participants. I can see there are so many people online and the comments are coming in. We'll keep the platform open for a bit. So thank you for your patience. Thank you for active participation. It's been 7 great days of learning and unlearning and relearning. So thank you so much. And I wish you a brilliant day ahead. Thank you. Bye-bye. Cheers.